stand behind the group check.
Hi there. My full name is Gary Moore lowercase and my born date is 290487. My full address is 14 Vicarage Lane, Sherburn, YO178PL.
So you're here today regarding one matter only as an allegation after asking for that violence. We call a summary only matter in the magistrate's court. If you plead guilty today, you'll stand convicted today, or you may be sentenced at a later date. If you plead guilty, you will receive credit for your plea and your sentence will be reduced. If you plead not guilty, then there'll be a trial, of course, and if found guilty of trial, your cost will be much higher.
Well, I'm innocent of all charges made against me from the incident.
That's not what I asked you. I'm going to ask you more whether you're guilty or not guilty. I'm asking do you understand what I said?
I comprehend what you're saying.
So it said that between the 30th of May and the 4th of June of this year at Sherburn in Malton, that you pursued a course of conduct which amounted to the harassment of Alicia Marie Barton, in which you knew or ought to have known amounted to the harassment of her, and you made numerous calls and sent numerous messages to her, despite her asking you not to contact her. Do you plead guilty or not guilty?
I'm innocent of all charges made against me. Innocent of all charges made against me.
Mr. Movie,
yes, sit down, Mr. Clark. Please, Mr. Moore.
Thank you.
Thank you, Your Worships. The allegation is one of harassment in relation to the neighbour. The Crown are applying for screen but the response to that has been excessive and aggressive, and as such, to give them that to be aided by screens. I would also ask, because I know the defendant is not legally represented, I would ask for section 36 preventing from cross-examining the complainant in this case, please. The PET bomb has been completed in relation to the prosecution evidence. Currently
The incident of the crash happened on the 28th of May, and the defendant drove off without giving any insurance details for 3 days, and she come back.
None of that's to do with the question I just asked you.
What did you ask, sorry?
So there was an application for screens, which is where, at the trial, the complainant will be behind a board or something like that so that you can't see her. Is there anything you would like the magistrates to know about that request? What do you think about it?
The defendant could, well, the other person in question can do what she wants, because I'm the victim here and I've been through all this abuse.
So you've got nothing to write on that. And there's also a request for you to be prevented from cross-examining her personally. And if that were to be the case, a solicitor would be appointed to you for that cross-examination. Is there anything you'd like the magistrates to know about that?
Could you digress what that means, please?
So at the trial, you have what's called evidence in chief and you have cross-examination. So evidence in chief is where a person comes into court and they say this is what's happened. And then cross-examination is where the other side challenges them on their evidence. Now, in this particular case, because you haven't got a solicitor, the prosecution are asking that it not be you personally who does it. And if that were to be granted, there'd be a solicitor assigned to do it. Of course, they'd speak to you and ask what questions you want asking, but you wouldn't do it the other person.
All right. Could I get one of my own peers to question if it goes to trial? Well, I want it to go to trial anyway.
Then yes, but in effect, if the court were to grant the application, then there'd be a solicitor assigned. Now, if you then got a different solicitor, then that would be for you. But in reality,
and when this goes to trial, how would I be able to reverse the charges? Because I'm the one that's been civil. I've had civil conspiracy and abuse of process by malicious prosecution made against me.
Well, this court's not here to entertain those discussions. You've been charged with an offence by the Crown Prosecution.
Yeah, but after the trial, and I
This
found
court
if
is here.
once the trial
This
goes
court
and
is
my
here.
innocence has been proven, can I have a chance to get her done for the stalking and harassment she's been committed against me?
If you wish to make a complaint regarding a complainant, then that's open to you to discuss that with the police.
And
but that's not what this
could
court's here
I
to discuss.
verify if my affidavit has come through?
I have seen it.
Yes, thank you.
It has absolutely no bearing on this case beyond obviously the fact you plead not guilty. What you say in it might form part of your evidence at the trial, but this is not the trial.
Yeah, no, it's not the trial. This is the first hearing. Yes, I understand that. I comprehend that. I mean,
So, Your Worship, you've heard the representations on the request. In regards to the screens, of course, you'll consider whether or not it's likely that the best evidence will be given by the benefit of the screen, of course, whether the defendant has no particular issues with that screen being granted. And with regard to the section 3638 election, of course, if you feel that it would be inappropriate for this defendant to be cross-examining and complaining directly, then you would grant such an application. I don't know if there's any solicitors in the room who are amenable to taking the
I don't want
instructions.
I don't need a solicitor to vouch for me. I can do stuff myself.
Well, that's the very point, Mr. Miller.
Thank
If
you.
the allocation were granted, you wouldn't be entitled to.
Yes, we're happy to make both grant both applications.
And of course, I turn to the defence advocates in the room to ask who would like to take the instructions. Ms. Whelan. Excellent. It's GSB, isn't it? You're amenable to that. Someone from Greater will be interested in possibly taking initial instructions from you today.
Could you please repeat that, please?
So someone from Gravesend Basin will be in touch with you to discuss the questions that will be asked at cross-examination. It may be that can be done today because Whelan is here, and maybe she can take some initial instructions today.
Is this for legal advice?
No, it's for cross-examination. If you wish to have legal advice as well, then you need to make an application either for legal aid or to pay GSB to represent.
No, I don't want no thing. I'm capable of defending myself.
So we have something called a preparation for effective trial form, and what it does is it narrows down on the trial day what the issues are, what they're not, and that way the trial runs much shorter, much smoother.
Would I be able to apply for a trial by jury?
No, I'm afraid not, because this is what's called summary of the offence, and so it's not capable of being
Could you
tried
please
by a
digress
jury.
what that means?
So it means it's not capable of being tried by a jury. It can only be tried in a magistrate's court, and then magistrate's
Could you
court.
give a reasonable reason why?
Because Parliament says so. That it's a statutory provision. It's not a decision we are making. It's simply this offence, this summary only.
Okay.
So there's a form. Ordinarily, we'd ask a defence advocate to fill it out, but of course, since you don't have one, I'll go through it, ask you the questions, and I'm happy to tick the boxes and make sure that's all in order for you. So you understand, of course, because I'd already given you the advice that had you pled guilty, you would receive credit, so I can tick that, say yes. This hasn't been covered, but I can tell you it now. If you were to not attend for your trial, I have to advise you that the likelihood is that trial will go ahead in your absence. Do you understand?
I'm going to attend by trial because
I have no reason to doubt that you will. I just have to.
I'm the victim here that's been abused by process.
So Nick's please know that because there's only one charge. I'm taking it from what you said that you don't wish to make a plea of guilty on different facts.
I'm innocent of all charges made against me.
That's fine. These are just standard questions.
How do I? I've got loads of evidence and videos, footages of.
Well, depending on what that is, it may be something you bring to the trial if it's admissible.
Oh, can I bring it? Do I need to bring it to you first for you to? Because, like I say, I've already sent it to the members of the public that are getting involved.
Well, that's a subject we're going to cover because I suspect that having read your affidavit, there's quite a lot of those members of the public who are not going to be involved in the trial because what they speak of in the affidavit is entirely hearsay and simply would not be admissible in a criminal trial. But we'll cover that.
These are witnesses from actual neighbours, and one of the witnesses was the other person's witness, and he found out she was lying, so he come and told me what her intent was and what she was aiming to do.
So that's hearsay. In fact, it sounds very much like
No, it's he was actually with her from the start of it when the crash happened. When she crashed into my car on the 28th,
yes,
she used him as a mediator.
The trial is not about the crash, but we'll go through the questions. The witnesses come later. Okay. So clearly you don't wish to plead.
And would you be able to send someone down to these witnesses' house to verify everything that's gone on? No.
Your witnesses are your responsibility.
Yeah, but because of two of my witnesses, because of their health, they can't make it to court. So if you could send someone from the court to their home to, no.
Your witnesses are your responsibility. If you wish to have them as witnesses...
That's why I'm asking if you could send someone from the court to go and speak to them.
No, that's not how it works. We don't have those members of staff that do that, nor do we have any powers to go around interviewing people. So
how would I, because two of them won't be able to come to the court.
Well, that's for you to sort out. Now, maybe that if their evidence is actually admissible at trial, which, as I've said, quite a lot of what you sent in that affidavit would indicate that what they're prepared to say is hearsay would be admissible anyway. But if they were giving valid evidence, it may be possible for them to do it by video.
They have got valid evidence. Literally, they've got the evidence to prove what's...
different to what's in the affidavit, because what's in the affidavit is largely hearsay.
It can't be hearsay when the neighbours are the ones that have actually vouched to verify what I've said is to be true.
Right. Well,
They've witnessed it throughout the actual period of the harassment and stalking my next door neighbour's been doing.
5 times now. We'll cover that when we get to the witnesses.
Okay.
So I dare say so, yes. So do you dispute that you were present in this scenario, i.e. you are the person who's been conversing with the claimant?
No.
You don't deny that?
All this is false accusations and reports and allegations made against me just because she reversed into my car, drove off without giving insurance, went missing for 3 days, and then she come back with a whole lot of police and threatens to kill, which never happened. And I clearly deny none of it happened. There's no evidence. And I only text her nicely to give me her insurance details so I could get this sorted out. And she's created all this fabricated stuff to hold against me to prevent her from paying any damages to the car.
Your Worships, I think I propose, given what we've just heard, to mark pretty much everything that's disputed for the trial, and then it can be ironed out at that stage.
And could I get it on date as well? The thingy happened on the, because on one of these statements saying that she reversed into my car on the 30th of May, when it was on the 28th of May when she created the accident under the influence of pharmaceutical substances. She drove off for 3 days and not give any details over. So that's where all this is like accumulated from.
That would appear to make perfect sense because the charge is between the 30th. You say is
that's when she come back after drove off. She crashed into my car on the 28th at around 10 or 11 o'clock. When I asked her to pass me her insurance details nicely, she just drove off basically after ranting.
None of that changes what I just said. It would make perfect sense. If the accident's the 28th, you're saying she then disappeared for a number of days. The Crown is saying that the harassment takes place between the 30th and the 4th of June. So that makes perfect sense. What you're saying is she wasn't present. The Crown is saying you didn't start harassing her until 2 days after.
No, on the 28th was the only day I've sent her the messages to say, can I please have the insurance details?
Right, that's fine. We know
and then 2 days of silence, she come back on the 30th and claimed all this to happen on the 30th when I have the video footages and the picture evidence with the crash happened on the 28th. So she's like fabricated all this.
I've already explained to you why that is not a problem.
Yes, right, thank you.
So was Mr. Moore interviewed? He was. Have you seen the summary of the interview? It should be contained within the IDPC.
I remember the interview anyway because, like I say, I'm in honour and I have to speak the truth, so the truth doesn't lie.
Okay, so you're not disputing the interview?
No, like I say, I was in the interview and I expressed what's happened, told them exactly what's the truth.
So in effect then, when I put down the issues, what you're saying is the entire history, the entire matter is fabricated, you contacted her once and once only.
All this goes way back.
Right, well, we're not interested in way back.
No, but this is what I'm saying, this is a lead up and escalation to it. It all goes back since I was with my girlfriend at the time.
That's something that you might, if you wish to make a complaint against the complaint for all of that, that's up to you. We're here for the period between the 30th of May and the 4th of June. And for that period, from what you've said so far, what you say is you contacted her once to request the insurance.
That was on the 28th. And because the police have got my phone, which has got proof in it, to say that it all happened on the 28th and on the 29th and the 30th, I had no contact with said neighbour. And then I've had no contact ever since. The bail conditions and all these fabricated accusations are just being brought forward by the CPS to try and caught me up into these courts.
Okay, so what I've written is the defendant did not make any contact with the complainant throughout the period. He contacted her on the 28th of May 2025 to obtain her insurance details and no further.
Which my mobile phone messages will state that, and they won't state anything other than that, because what I've read through here is absolutely diabolical of what the false accusations have been going through, from the help of the CPS, getting my next door neighbour to act as an agent provocateur to create civil conspiracy and abusive process by malicious prosecution.
Right, well that's up to you, Mr. Miller, if you say so, but in the here and now...
It's not say so, as I know so, because I was under investigation for 6 months.
The CPS and the prosecuting authority, they charge you with an offence.
Yes.
And we're here to deal with that.
Oh, yeah, that's fine.
Do you have an intention to make a defence case statement?
What do you mean? Can you digress, please?
So, in effect, in the magistrate's court, it's voluntary. The defendant or a defendant's advocate can draft what's called a defence case statement. Now, what that does is it outlines to the court the exact particulars of what your defence is.
That's why I made my affidavit of truth.
Right, but that's not in the format of the defence case statement. So I'm asking, do you wish to make a defence case statement or not? You're not required to, but I have to ask the question.
Until I can actually break down what you mean by that, instead of using legal processes, then I'll have to say no. Pardon?
Legal processes.
Yeah, exactly.
This is how it works.
Well,
So I'm going to put no for the time being. If that changes, then by all means let us know that you do intend to serve.
what does it intend? Does someone come to my house to text statements?
Nobody's coming to your house.
What does it mean? What do I have to do?
Well, you don't have to do anything. We're asking if you intend to make a defence case statement, which is basically a document, as I say, that fulfills the particulars. I'm not going to go into what those are with you now. You may wish to discuss that with the solicitor as to what a defence case statement is. You're not required to, but it's on the questions that we ask.
Well, everything that I've stated on my affidavit of truth to show you the escalations of why it's ended up to where it is now with my next door neighbour.
Thank you. Are there any applications for any standard directions to be varied? Is there anything in particular you think you need in order for the court hearing to be effective?
Yeah, I could ask if, like I've mentioned it before, is 2 of my witnesses need someone to go down, because they've verified the whole scenarios from start to finish to this present day.
That's not going to happen. Is there anything about the courtroom itself? Do you need extra breaks? Do you need any sort of...
I'd just like to get it over and done with, because I need to get on with my life. This is just putting a burden on what's happening.
Okay. No ground rules because there's no use and it's not a trial of laws. Okay. So in terms of Ms. Barton and Ms. Berry, how long do you think you're going to need, Chief?
Half an hour.
Half an hour. And Mr. Moore, unless you feel differently, I'll put down to 30 and cross as well. Obviously, not be yourself, it would be your advocate. It seems logical unless there's any reason to say that it would be different, that you need about the same amount of time in your cross.
Is this for like cross when I'm getting asked questions and I've got to ask questions back?
This is for when the witness, as in this case, Ms. Barton, has given her evidence, and then your solicitor will ask her questions about her evidence.
And witnesses, where are the witnesses on here? Because I don't see any witnesses. Like I say, the defendant's witnesses are just hearsays as well. They never witnessed nothing. Because of the help of the CPS, they've just made all this blown out of proportion.
Well, I would ask the question about prosecutor. I haven't read the statements of the other witnesses. Is there a suggestion that they're hearsay?
Well, they will be hearsay, because if I don't have any acknowledgement of it, then it's just hearsay, because half of the time was done coercively behind my back and secretly being recording me and my in and outgoings of my house. I have video footages of this from her CCTV camera that she's got it all in my garden of me coming in and out of my garden. This is invading the privacy. And I have all the CCTV footage come from one of her witnesses, which is Keith Snowden, who turned against her because of the lies and give me all of the information she was using.
For a very long time, and I'm yet to hear anything that's relevant to this trial.
Well, it's all relevant because it's all part of the stalking and harassment that I've been receiving.
If you continue to interrupt me, Mr. Moore, this is going
Sorry.
to either take a long time or a very short time, because if you continue to interrupt me, I will ask you to be removed from the court and we will continue the rest of these proceedings without you. Okay?
There is the complainant and the rest are police officers.
Ah, right, okay, so they're only speaking of the engagement with the complainant, not the allegation itself. Are they needed principally because they exhibit something? Is that the...
So there's the arresting officers.
Is that Easton, Compton, or Easton? So she owns the arrest.
Yeah, Pearson, she rang the police and told the police that I was operating a vehicle. This is continuous harassment from there, but that's what...
Yes, I've heard this before.
Yeah, right.
You're interrupting
Sorry.
discussions I'm trying to have. So, Mr. Pearson wants to well, yes, although it doesn't necessarily
Yeah, it is just about the election, not.
Do you need Mr. Pearson to attend in person? He's simply the officer who arrested you. He doesn't give evidence.
Well, he doesn't know anything other than the arrest and what false accusations were made forward. And
so are you happy for that statement just to be read rather than asking him to come?
I don't want him to come now.
Okay, that's fine. So the marking was read.
Because, like say, he hasn't witnessed nothing. He was just the arresting officer at the time.
Well, on this point, I agree. That's why we're asking if it could be read, because he's not going to give any
Yeah,
evidence about the incident
yeah.
itself. Hovington?
Hovington interviewed, seized the mobile phone, and exhibits the interview.
Okay. Well, that sounds very much like Mr. Pearson then. Of course, she's just giving evidence of what happened with you after.
It's Mrs. or Miss, because it was a Mr. Pearson, Gavin
Yes.
Pearson.
Yes, I'm now talking about Miss Hovington.
Miss Hovington, is that the blonde-haired woman that interviewed me?
I have absolutely no idea. Oh, yes. Well, yes, the person who interviewed you,
yeah.
I do know. So
Because she gave up the case because of whatever she found out, and she passed it on to somebody else.
Right. Okay. But what I'm asking is, in effect, do you dispute anything she's going to say? She's simply.
Well, they're just hearsay people from, because I've been under investigation, you see, for 6 months, and had CCTV footage as surveillance by the police.
Right. Well, Mr. Miller, what she says is not hearsay, because all she gives evidence on is the fact that she interviewed you. She doesn't give evidence.
Yeah, and in the interview, I stated what's
so
happened.
Yeah,
that can just be read. Yeah.
And Easton.
I believe she gave up the case as well, Miss Easton.
Her statement contains hearsay about another neighbour that she's spoken to.
So she's going to need to be called then, really, because we're not going to get an agreement on that statement, are we? So, how long do you think for her?
3 minutes.
3 minutes. Okay. And presumably the same amount of time for your solicitor out to cross-examine, if appropriate. And Eric Wilson.
Eric Wilson exhibits the typed recording of the interview.
Okay. And presumably you have no objection to that statement being read. All he does is he brings the typed copy of the interview which you yourself.
Like I say, I'm happy with what you need to put, because I say I'm in the truth here, and I'd just like to get this over and sorted out, because.
So, Mr. Miller, bearing in mind that the court is only interested in what happened between the 30th of May and the 4th of June, and specifically on the allegations that you harassed the complainant, how long do you think you will need to give your version of events to the court on the trial?
As long as it takes. It shouldn't take that long, because I couldn't put a time on it. I couldn't, I'm afraid.
20 minutes, Your Worship, so that's probably sensible. And the same in cross, I imagine.
I'd say 45 minutes.
Okay. So, usually, Your Worships, we direct service of any outstanding evidence and, of course, compliance with the duty of disclosure within 28 days of today. That will be the 12th of January. And we've already got the appointments. So that gives us an estimated trial length of, well, on paper, 2 hours and 10 before we start deliberations. However, I think Your Worships, you may wish to consider listing this for today, given what we've heard and all the extraneous factors around the case.
Is this the trial date that what you're talking
Yes,
about?
we just work out how long it's going to be, so we know when to act.
Yeah.
Mr. Moore producing evidence.
Yes, apologies, it occurs to me that I'm filling in this form rather than Mr. Moore. Mr. Moore, So bearing in mind obviously what we've already discussed, in terms of witnesses that you'll be calling, I understand that you've sent a number of affidavits. The bulk of those I have read, and what they discuss is purely hearsay, i.e. Mr. Muller has told me this, Mr. Muller has told me that. Particularly the one from your mother seems to refer entirely to hearsay, what you've told.
I mean, mum's a witness. She got arrested when she come to my house because the next door neighbour rang the police on her for coming to my house to check on my well-being, and because of all the harassment and stalking I've been getting, I've been like trying to lock myself away.
Right.
And she's been checking on me to see if I've been eating and see if my mental well-being's been all right. And
None of that is evidence in this trial, is it?
she got arrested because the next door neighbour rang the police on her for coming to my house, which my mum verifies as to be correct, because the Yorkshire Housing's been getting involved for the same predicament.
But whether it's correct or not, none of that's evidence in this trial, is it?
Yeah, it is evidence of trial of the harassment I've been receiving,
But this trial is not about the harassment you've been receiving, it's about the alleged harassment you've been given.
which is
As I
false.
say, as I say, if you wish to have a complaint with the police against the complainant, that's between you and the police, not between you and the
Well, going to the police is when can you get your justice sorted?
That's, with all due respect, not for this court to get involved in. What we're here to do is to determine whether or not you harassed this complainant during the times that you're alleged to have.
Yeah, which I'm innocent of all charges.
Right, you said that, but my point is, the suggestion that your mother got arrested has got nothing to do with this trial.
No, well, it has, because it's all intertwined. It's just because the CPS is trying to work out to try and ostracise me and get rid of my witnesses to try and do legal jargon on me on the trial
I
day.
suggest, Your Worship, on the basis of what we've heard, I can see no way in which that would point in this evidence.
No.
Is there anybody else, Mr. Muller, who will give actual evidence as
Yeah,
to the issues of the trial?
Keith Snowden,
And what will he say?
he'll give you all the evidence you need of what's been said and happened, because he was her witness from the start of it, and he turned on her because of the lies that she'd been committed and her intent. What her intent was, that he said, no, I can't just go to court with you because you're destroying someone's life who was innocent and you're making all this stuff up. So he come around to my house, which I have a video footage of and a voice clip of him actually stating what is going down, and he's the main witness, which was one of her witnesses, which stated in here.
Was he ever a crown witness?
PC Easton spoke to him, and he refused to write it.
But he's refusing to put a statement and sign pen and paper to what I'm saying. That's why I'm asking if you could send someone down to his house to verify this because of his health. Does he have to come up like?
Yes.
All right.
So, in effect, then, what will he? I asked you what evidence he'll give, and you said he'll give all the.
It's got video footages. It's got video footages, text messages of the intent and lies of the group of people that was conspiring against me.
Again, this is not the purpose of this trial. You keep coming back to the alleged harassment that she's giving to you. That's not what this trial is about. That's something that you need to take with the police.
Well, I've tried taking it to the police because you don't get no help off them.
No success, Mr. Moore, does not change the fact that it's got nothing to do with this trial.
Say that again, please.
Just because you're having no success with the police doesn't change the fact that it's not relevant to this trial.
What do you mean by
This
that?
trial is about whether you harassed the complainant.
Oh, right,
not
yeah.
whether she harassed you.
Oh, yeah.
So, in terms of the evidence of this witness, what will he say about the alleged?
He'll tell you the truth of what happened.
That's not an answer.
Well, I'm saying if he's got the evidence to prove my innocence and the ongoing situation, because on here it stated that Alicia was using him as a witness, but he refused to put pen and paper because he found out the lies and the deceit what the police were doing. Keith Snowden, he lives at 79A St Hilda Street, Sherburn.
You know his date of birth?
No, I do not know. He's 50-something years old. And my next door neighbour, Jason Sellers, he's like eyewitnessed all of the events to present day because he's been getting harassed by the said neighbour for witness intimidating for being on to man.
We keep going round in these circles, and I keep bringing you back to the trial issue. Is he a witness to what you were alleged to have done? Rather than what
He's a witness. Yeah, he's a witness to basically everything. These are the two witnesses. My mum's. I've kept my mum documented on the 19th of December last year because when I split with my girlfriend, I couldn't figure out what to do with all this stalking and harassment I've been receiving. So I've been helping. My mum's been helping me document everything down, and that's when I said to my mum, "This is times and dates it's happened, which I've got it all recorded, and she's kept it up to date. And when she come and see me, she fell victim to the false accusations because she got arrested.
You keep talking.
Yeah, I know, but I'm just explaining to you what's.
You haven't explained anything to me. You've not told me what this witness sees.
Well, he's seen her scratching my car, parking a car next to mine, hailing abuse, threats towards me, saying her brother's coming to fill me in, that she's going to run me over, etc., etc.
But none of that is to do with this trial, is it?
Yeah, it's something to do with the truth, because it's like I said, the CPS are trying to mix it up to try and cut me off and try and get me in legal stuff.
Not remotely to do with this trial. Does he witness your conduct over this period of time?
Yes,
Not hers,
he has
yours.
witnessed my conduct.
Right.
This is what I'm trying to say. All of the witnesses I have on there are witnesses. They're not hearsay witnesses. They're my neighbours that's actually witnesses. My other neighbour has only just realised to the lad.
So what's this person?
Jason Sellers. He lives at number 10 Vicarage Lane. I think it's Vicarage Lane. It's on the corner house.
Do you know his name?
No, I don't know. He's maybe a bit older than my other witness. Or might be the same age, roughly.
Your worship's known direction that the date of birth is provided to be provided to court and CPS.
Sorry, I want to.
The date of birth of that witness.
And is there anybody else?
From the 19th, my mother, she's been at my house while all this abuse and threats are being made towards me from said neighbour. She's witnessed it with her own eyes and ears, and she was the one that just told me just to let her keep going on and let her keep digging her hole. And she's been advising me just to keep quiet and keep out of her business.
Right, but does she witness what you did or didn't do between the 30th of May and the 4th of June?
No, it would be just hearsay, my mum on that certain subject.
Right.
Because I rang her up to keep her updated with what's happening, because she lives in York, you see, and I live in Sherburn.
That's fine. Is there anybody else then? Or is it these two?
Then Keith Snowden and Jason Sellers are the actual main witnesses to all of this going on. My mum is a part witness towards the end, coming up to the end bit. Well, she didn't witness the early part of it. She witnessed the actual where I was at my house getting loads of abuse, trying to get a reaction off me so she can ring police and get me arrested.
Again, that might be a witness to a subsequent trial that you have against the complainant, not this trial with the complainant against you. Okay?
All right.
So I think that covers it, your worships. I think probably direction around 20 and 20 for each of those witnesses would seem sensible.
What do you mean 20,
So
23?
20 minutes for them to tell.
Okay, yeah, that's fine.
That's what you're saying.
Yeah.
So they'll probably be about the same.
Yeah, that's fine, yeah. May I ask a question?
What was your question, Mr. Moore?
So, could you get my phone released from the police, please? Because I need it for.
I can't get your phone released from anywhere. That's not for this court.
I thought you had the power that you could get it released.
No, fair enough.
Who do I go to get that? Because I need the phone, you see, to sort out my
The police,
universal.
and if they say no, the Independent Police Complaints Authority, I suppose. Right, so I'll ask for a photo.
And is that the only witnesses that the said person's got? It's just the police?
And herself.
And herself? Oh, so it's all just hearsay then?
No, that's not what hearsay means.
Well, no, I'm on saying it's all hearsay anyway, because what she's saying is a load of fabricated stuff, and you're saying what I'm saying is a load of fabricated hearsay.
Hearsay means where someone gives evidence of something they themselves have not seen. So she is saying, well, I have seen it because this is what happened. Now, that may or may not be true. I don't know. That's what the trial's to determine. But it's not hearsay because she's going to say what she says she saw.
Okay.
So it's not hearsay.
And I get the chance to defend myself in that process?
Yes.
Yes.
Yeah, you'll give your evidence and your solicitor or the appointed solicitor will cross-examine.
And what is the reason why I can't cross-examine?
Well, because the bench have directed that you don't, because you're not represented. You're the alleged defendant. Now, in this particular case, it's a harassment charge, and the magistrates don't feel it's appropriate for the person who's accused of harassing a person to be the same person who is asking those questions. And so they appoint the solicitor to do it in your behalf.
And what will happen after the trial date? If whoever's found innocent and whoever's found guilty, what will that be happening?
Well, the only person who's going to be found innocent or guilty is yourself, the only person who's on trial.
All right, and if I'm found innocent, is she going to be getting done for wasting police time and numerous other stuff?
Not necessarily. That again is between you and the police. If you feel that she has a charge to answer, then you report that.
I tried bringing this to the police before and they just ignored it and took her case.
Right. Well, this court can't do anything about that. We're a court, not a police force.
So how do I get her done for what she's committed against me?
Again, if you feel the police are not acting appropriately, your avenue is to complain to the appropriate bodies for police incompetence. But that's not this court. 27th of March is suggested, Your Worships, for a full day. Is there any reason you couldn't do the 27th of March?
27th, any reason I can't?
Yeah, would that date work for you?
And like I say, if I can't, I'll let you know 2 weeks or 3 weeks prior.
I'm just going to check with the witnesses whether they can do it as well.
I just need to check it. What day was it?
27th of March. Excellent. So 27th of March, Your Worships, I think the suggestion is that you enjoy and should continue to enjoy it.
So, Mr. Moore, you've heard what's been said. The trial will go ahead on the 27th of March, starting at 10 o'clock. You may wish to be here a bit earlier than that for any discussion to take place. In the meantime, you're granted unconditional bail. That means that if you do not come back to court on that date and time, you commit an offence of failing to answer bail, that you can be sent to prison. Do you understand?
Oh yeah, I understand.
If you commit any further offences whilst on bail, you can expect your sentence for those offences to be greater. As you know, this matter is listed for trial. If you do not come to court on that date and time, the trial may go ahead in your absence. Do you understand that?
I comprehend that. I want to get this sorted out because it's blown out of proportion. This for just asking for insurance details, it's just gone way out of proportion.
Okay, you can go. I don't know, did you wish to see him before you go?
I've got a couple of people ready to deal with next.
Right.
I do have the contact details and we can get in touch with them.
Okay.
Have you got the right contact details?
14 Vicarage Lane?
Yes, that's correct. Yes.
Right, you know.
Yeah. All right. Thank you very much.
Thank you. You can go.
Right. Is that it? Enjoy your day, you lot. Have a blessings to you all. That's it.
Hello.
Hello, stranger, how are we doing?
I'm alright, how are you?
I'm good, thank you. I'm